The gentleman from Kentucky is recognized.
Thank you, Mr. Chairman. When we debated this in the committee, it seemed like the major objection to this bill from the other side of the aisle was that it took power away from the executive branch and gave it to the legislative branch, that the REINS Act, that was its major defect. I think that's its major attribute. I mean, when we say executive branch, it's not the president who writes these rules that have the force of law. It's career bureaucrats who are writing these things. And then they have the force of law, and they can carry prison terms, as we see with the pistol brace rule. There can be prison terms attached to these. These are effectively law. But why would we be here in this body arguing that we should have less power? I mean, our power has atrophied considerably since the founding of this country. One of the specific objections I heard, though, was that the experts would no longer be involved, and that we didn't possess the knowledge required to make these rules that the legislative branch is making. Representative Hageman, do you want to address that? Would experts still be involved in lawmaking? Would they have no say whatsoever?
I would, in fact, argue they would have more say now, because we would be talking to our constituents, the ones that have the expertise in their particular areas, whether it's business or providing medical care or whatever that might be. I'd like to read a paragraph that goes directly to that issue, that it was written by Philip Hamburger. Philip Hamburger is considered perhaps the foremost expert on administrative law in the United States. And he has written something about this whole delegation issue that I think is extremely important for everyone to understand. It's easy to talk about cutting off of fingers and toes in some kind of a dystopian world that we're going to live in if Congress actually does its job. And it's easy to say things like that, but it's not reality. It's not reality, not just because the experts would still be involved, but it's not reality because it's not the way our country operates. But I'll just read this real quickly. In addressing this issue of expertise, the result is different from the administrative state, but not as severe as might be supposed. It is often feared that a barrier to the delegation of legislative power would require Congress to make all rules and would bar any agency discretion. But nothing in the Constitution is so rigid. Instead, the Constitution confines binding agency rules to Congress and binding adjudications to the courts, while leaving room for a wide range of other agency rules and adjudications. Even as to binding rules, the Constitution would require little change in their framing or formulation. Agencies still could frame rules very much akin to current agencies. The only difference would be that whereas now binding rules can be adopted by heads of agencies, a more constitutional approach would require agencies to send such rules to Congress to enact. And again, we're talking about a 12% subset of that. We're talking about only the major rules. So again, I'd like the number to be lower, but at 100 million in 2021, 12% of the Biden administration's rules would consider major rules subject to this to the REINS Act. So again, I'm with you. I think we ought to do our job. I think we are the experts. We have the ability to bring in any experts that we want to on a particular topic. The agencies would absolutely have the ability to come and explain why a particular regulation was so important. We would work with every single agency to make sure that that happened. So, you know, it's easy to live in this dystopian world that we're all trying to kill everybody and cut off their fingers and toes and legs, but that just isn't the case. The reality is the REINS Act does nothing more than for a small subset of the rules, we're attempting to take back the authority that Congress has under the Constitution.
So the experts would still exist. I mean, they've got to administer these laws, so there would still be experts there, and they would still be writing rules, but they would be sending them to us to adjudicate with the best interests of our constituents at mind. And if our constituents decide we did a bad job of adjudicating their best interests, they can get rid of us. But they can't do that with these administrative agents. So, and also, I mean, what does it say to say that we don't have the expertise we need here in Congress to pass some of these laws? That's an indictment. Maybe we should have some more expertise here present among our staff and among the committee staffs. I don't know if you look at the proportion of funding that's gone to the executive branch versus the legislative branch, beginning with our country's founding to now, the executive branch has grown exponentially, and there they do possess experts. Maybe we should bring some more of that expertise here. But in the meantime, it's not up for them to write the laws. They can suggest them, and then we can decide whether we want to take the advice of the experts, and then our constituents decide if we've done a good job of adjudicating whether those rules are proper. There was another specific objection to the REINS Act in the committee. I haven't heard it here today except for a brief mention, and that is that it's not constitutional. That there was a Supreme Court case, INS versus Chadha, that said that you can't do this sort of thing. You can't have a legislative veto. Representative Hageman, do you want to address that and explain why this is constitutional and why it doesn't have the problems that the Supreme Court objected to in prior legislation?
Well, that decision, when that was raised during the hearing, we all looked at that case pretty quickly. It was very clear that it has absolutely nothing to do with the REINS Act, and that the REINS Act would never be considered to come within the admonition issued by the Supreme Court in the Chadha decision. I will go back to the Constitution and my Federalist Papers here. And, I agree with you. I think that we ought to study. I've spent a lot of time today preparing for this hearing because I thought that you would want me to know what I was talking about when I sat in front of you. I don't think that that's unreasonable to ask of all of our members of Congress. We ought to know what we're talking about, and we ought to know about what laws we're passing. That's just a minimum standard, I would think. But it's not unconstitutional because the Constitution says it's not unconstitutional. We're the ones that get to pass the laws. The only authority that the agencies have comes through us. And if they are either not authorized or they are exceeding their authority, we are the ones that get to rein them in. So it can't be unconstitutional when the Constitution says we're the ones that are supposed to be doing it. And Chadha does not say anything different than that. That referred to a legislative veto. This isn't about a legislative veto. This is proactive legislation going forward that to the extent that the EPA or USDA or Department of Transportation or Commerce or any other agency adopts a rule that has an economic impact of $100 million, then we get to say yay or nay. That's not a legislative veto. That's doing our jobs.
Absolutely. I think they were way off the mark when they tried to equate the REINS Act to a legislative veto, because in fact, what happens in the process here, just to remind folks who aren't as familiar as you are with this bill, the suggestion for the rule comes to Congress, and then we do our job as outlined in the Constitution, following exactly those principles. It's passed in the House, it's passed in the Senate, then it goes to the President, presented to the President, who can then veto it or sign it. And that is why it's not related to the case that they referred to in our committee. And I appreciate you speaking on that. Like I said, I've only heard a brief reference to it here today, but I wanted to clear that up for anybody who was concerned. Well, I'm going to yield back, but first I just want to close by saying that I feel like we're in some kind of bizarro world where almost half of Congress is here arguing that we shouldn't have the power to make law, that the executive branch is the only one qualified to make these decisions for our constituents. And I disagree, and the REINS Act would put this back in order, back in constitutional order, and I yield back, Mr. Chairman.
Thank you. With that, recognize my good friend from the great state of Texas.
I thank the gentleman from Pennsylvania, and I would just tell my friend from Pennsylvania that I was at Lukenbach, Texas on Saturday for my wife's birthday, and I know the gentleman appreciates Texas country music. And I wish the chairman were here, so he was talking about OU softball. I could regale University of Texas baseball being in the super regionals. We could have a little Longhorn Sooner battle, but I'll try to do that when the chairman comes back. I wonder really quickly if my friend from Kentucky would tell the story quickly for the Rules Committee that he told in the Judiciary Committee of the gentleman from Kentucky that was the genesis of the REINS Act. Oh,
I would love to speak about one of my favorite constituents, Lloyd Rogers, who wrote the REINS Act. He had this. He was a Korean War veteran He came back, he ran for county judge executive, and he was troubled at the degree to which the administrative state was running things, particularly our federal government. So he wrote this bill, and he gave it to the congressman before me in this district. And the congressman said, that's a pretty good idea. Let me take it to our lawyers, and Ledge Council reworked it. He introduced this bill, and it's one of the most popular bills in Congress. It's the one I get the most phone calls for. And Lloyd Rogers is still with us. He's watching every one of these hearings. He's very inspired. This is another part of the way the process is supposed to work, according to the Constitution. People come up with an idea, and they bring it to their congressman. They don't come up with a regulation and take it to the regulators. And so Lloyd Rogers epitomizes service to our country and the way this process is supposed to work. And I look forward to passing this and then going back home and shaking Lloyd Rogers' hand. Thank you, Mr. Roy.
Well, I think my friend from Kentucky